Good morning, John
Oh,
Dent.
hi, Mr. Dent. How are you today?
Well, I'm coming down with a cold, I think, but
You can get better.
Good morning,
Hey, have
James.
at it.
excuse me.
Said
James,
have at it.
Okay.
Mr. Gibson, you're
Well,
up. Mr. Dent.
thank you. Your honors. Again, good morning to you all. I guess in these circumstances, I've had to do this several times before in the first DCA, and it's kind of strange, but able to sit in my chair comfortably and do oral argument in a court seems kind of strange from all the years I've been doing them, standing on a podium in front of you guys in the mornings. But anyway, so this is anew. What we have in this case is that there were two individuals, two young ladies, that ended up getting together intimately. One of them, my client, owned a home that she had purchased, had been paying on for some time. When she took the other young lady in, eventually necessitated by a balloon mortgage maturing and my client not having the ability to secure refinancing, which at that point there was no choice. She wasn't in default, but it was a balloon mortgage. It was maturing. She had to come up with the cash to pay it. So there was an offer accepted to have the plaintiff, Michelle Bernone, to come in and aid in the assistance of refinancing because my client had been turned down from loans herself and a mortgage, redoing the mortgage. So she came in and agreed to sign in the transaction solely to aid in the refinance of the property. As I say, my client had paid on it for a number of years, had lived in it. It was her home. She did take Michelle in with her, and ultimately the financial condition ensued, and she was faced with a problem of not being able because she was in a balloon mortgage. It was
Mr. Dent, your first issue is whether a deed without consideration given to secure financing is a mortgage under the statute.
yes.
What you just said sounds like consideration. I am going to sign on the promissory note. I'm getting a deed. I am going to share the liability, at least on paper, for the obligation of refinancing. There's also evidence that they paid out of a joint account to which they both contributed expenses and so forth. Why does that not in and of itself amount to adequate consideration?
Well, there was no adequate consideration in the original transaction. Thereafter, they found themselves in the position of either Michelle moving in and paying rent, or else she paid half the expenses to maintain the property.
So your position is that the acceptance of liability, putting yourself on the line to be liable to a money judgment to the lender by Ms. Bernone does not constitute consideration?
No, I don't believe it does in this circumstance. She came and offered to do it to help out a friend. There was no discussion that there was an agreement. Nobody agreed to whatever. She just offered, came forward as a friend, okay, and offered to be the ability to end up signing on the paper in order to secure the refinancing. What the difficulty was is that my client before that had gotten into a balloon mortgage. She didn't understand what that meant, and she was then faced with the fact that she had no choice but to refinance. She didn't do it. She had a close, intimate friend who came up and said, well, will it help if I agree to sign? The lender said, fine. To the transaction, the deed was not given because she had before that ever intended to give a deed to her. What occasioned the circumstances was faced with the default on the loan because she couldn't pay the matured balloon mortgage and then suffer a foreclosure. She came forward. Now, that cut off any other avenue, whether she could go to family, go elsewhere, whatever else, to secure the same ability. She offered. She came forward. There was never a discussion.
That didn't cut off any other ability. Your client
Well-
accepted the offer, assuming it was an offer as opposed to just a friendly discussion, but it certainly didn't prevent your client from securing other financing if she were able to. And
Well,
from the record, it doesn't seem like she was very likely to get financing elsewhere.
no, that was the difficult. She faced a situation that she was not able on her own, but that didn't foreclose many possible alternatives. The immediately, because of their intimate relationship, they became aware, and she offered then to, will that satisfy to sign on to the debt and the refinancing. So that was not, there was no, oh, if I offer then, and then I'm going to really own half. No, it was an offer because it was mandated by the lender, not occasioned by some prior agreement to grant or give or whatever 1/2 interest in the property. It
So,
was always,
Mr. Dent, if I understand your point in response to Judge Silverman's questions correctly, it's not so much that you're suggesting that this wouldn't have been, that the offer of assuming a debt wouldn't have been adequate legal consideration, but rather that the facts in this case, the trial court got it wrong and should have construed it as a gift. Am I stating your position correctly?
yeah, it's difficult how you construe it. A gift or whatever. The gift was, I will help you out to secure a mortgage. The gift,
But if the trial court was correct in rejecting the what you're advocating was in fact a gift, if the trial court was correct, then your argument is not that it wouldn't have been. I mean, the traditional formulary of adequacy of consideration is a peppercorn would be enough for adequate consideration. You're not suggesting that that assuming a debt that you had no prior responsibility for would not legally have been adequate consideration. It's just it wasn't given as consideration in this case. I think I'm understanding your argument.
yes, it was not given, it was not expressed, it was not that. It was an offer by a friend to get a friend out of a difficulty. That's all it was. There was never, they didn't discuss, there wasn't anything in the relationship. Oh, hey, when they got together, that you convey the house to me or do anything. It was totally necessitated by the maturing of a balloon mortgage. Without that factor, this transaction would never occur. That's what precipitated her doing it. She offered to do it. Okay. Therefore, my client never sought any other form of securing or getting herself out of the situation. She was aware of the situation, came forward and said, well, will it help if I sign on the loan? And in this case, it was agreed. The lender then advanced the funds and they went to the transaction. It was never intended nor any discussion of conveying at any time during the relationship to convey a half interest to the plaintiff, Michelle Bernone. It was never intended. That was the transaction. That occurred subsequent day after everything was over with and the parties parted and they separated. And we know in many relationships when separation occurs, everybody scrambles to position themselves, and she saw that in this occasion to take advantage of the situation that she had gotten into and claim that, oh, that was really, and that's, I own half your property. Now, she never paid anything to acquire the property. My client paid all of that. She, as a single person, was able to originally buy it, to make the payments up until she faced a balloon mortgage. How she got there, who advised her to get into such a loan, I don't know. But in this case, there was never an intent to convey anything. It was secure. It was purely a loan transaction. And when you put all the facts together, and there was no consideration that I could, that in this matter, she didn't pay her for half of it. Now we know the numbers, how much had been paid so far by my client to acquire this property. There was never a discussion, if there normally would have been, of some transaction accounting for or whatever. And the total impetus or that occasioned this transaction was purely faced with a mortgage that was a balloon mortgage that was maturing. My client could have, it was cut off. She came in and offered to do this transaction. Okay, at that point, understanding that that's all it was given to secure and to financing to maintain ownership of the property. There wasn't discussion. Oh, now you understand that I'm going to own half of this forever and ever, and that I'm not paying you or you're not paying. This case would be a good case to use to argue that people should never get involved in a transaction like this without somebody going to see an attorney to figure out what their rights are and not in this. They did this on their own. They got into the situation, and this transaction was not a deed absolute. It was given to occasion to secure the payment of money. And under that, it was in the nature of a loan, a mortgage situation, as opposed to a deed absolute. There's no discussion before, no agreement that I'm going to give you or deed you or whatever else half my property. She came forward and offered to do this transaction to help, quote, an intimate friend out of the situation she faced herself. So my client at that point didn't seek an attorney, didn't seek other alternatives. She accepted and trusted her friend at that point to deed the property surely as required to obtain the financing with her signature. And that meets the, and we look at the case in the McClendon versus Davis that we've cited in the brief, that that factual situation follows this case in the court interpreting it to be not a deed absolute, but a secured creditor-debtor transaction. The court, in citing the old case of Thomas versus Thomas, which appears to be still good law and keeps being upheld, but as I say, in the case of McClendon versus Davis, which is cited, the court stated an element that must be considered is the distressed circumstances of the appellant as well as the existing relationship of the debtor and creditor. And that's what we're saying. What were the circumstances that she was faced distressed? She had gotten herself into it, never understood what a balloon, but then all of a sudden it came about that she was going to have to pay, not because she couldn't make the payments, but because it was a balloon mortgage that was maturing. Her financial ability was not that she couldn't get a lender to advance her the funds. And so there was an offer made by the plaintiff to help her out. And so this was a distressed relationship, and the court stated in this decision, again, of McClendon versus Davis, cited in applying the rule in doubtful cases, the law resolved the doubt as to the intent of the parties in light of the advantage the creditor always has over the debtor whose property he holds, and will give the debtor the benefit of the doubt. That's the circumstance. My client was faced with a balloon mortgage. She was unable to secure financing and to refinance. She had tried. Okay, so in this case, she was a friend came forward. And that the relationship is here that you trust a friend. You trust a friend in what you're doing. There was no intent to convey or sell or transfer for no consideration a property that, as a single person, you were trying to hold on to, that you had managed to be able to acquire and make payments on, and that you were trying to establish and continue your ownership. A friend offered to help out when the balloon. It might be different if she was in financial and she was late on her mortgage payments, et cetera. But no, this was occasioned by somebody got her into a balloon mortgage. So she had to come up with the entire balance. She wasn't late on payments. She wasn't in default by the terms of the agreement. She had to come up with the money. Financially, she attempted to get a loan. She couldn't. The plaintiff offered to help out. Now, in that offer, it wasn't, oh, understand that I'm going to own half your property forever and ever. No, it was just, I'm going to help you get over the hump and secure the financing. And that's all this is. That's all this transaction is it's not an intent to a deed absolute. There was no consideration given to acquire the interest. She executed the deed in order to secure the financing that they secured. And so we feel that this comes within the cases that we've cited in the decision with the old Thomas versus Thomas Supreme Court decision, and in the third D.C. McClellan versus Davis. That what appears to be a deed on its face is not necessarily a deed. We take the total of the circumstances involved to weigh what the transaction really was. I don't think there's any doubt that there was not a transaction that she came and said, oh, I want to give you half of my property. I want to deed this property. Now, what occasioned it is she was faced with dire circumstances, a balloon mortgage maturing. She didn't have the money. She had attempted to secure a loan, and because of her financial conditions, was unsuccessful in that.
And Mr. Dent, you didn't mention whether you wanted to reserve some rebuttal time, but you are down to 5 minutes.
Well, why don't we, if the court doesn't have any other questions, I think in the brief, we've adequately expressed this. Let me reserve that time for rebuttal, if any.
Sure thing. Sure thing. Okay, Mr. Gibson? You're muted, Mr. Gibson.
A lot of people would be thankful for that, I'm sure.
You are the first one today. There's always at least one, and it's usually me. So
I apologize. May it please the court, I am James Gibson. I represent Michelle Bernone. She is the appellee before this court, and she was the plaintiff in the lower court. There are two big issues that were addressed in this appeal. The first issue, which was discussed by Mr. Dent, is whether this deed was or was not a disguised mortgage. The second issue dealt with some accounting issues, which again, we did address in the briefs, although Mr. Dent didn't talk about that. So I want to focus on whether the deed was a mortgage issue first. An important thing to remember is that order was a summary judgment order that was entered by the court of partition. And in that order, the trial court found that this deed was in fact a deed and was not some sort of a disguised mortgage. And although it wasn't spelled out in the trial order, I think the fatal flaw to the argument by Ms. Topjohn is that under 697.01 Florida statutes, that's the statute that says a deed can be construed to be a mortgage. The statute says that it can be that a deed, if it is drafted with the intention of securing the payment of money, it can be construed to be a mortgage. The cases say that the payment of money is monies owed from the grantor, in this case, Ms. Topjohn, to the grantee. In this case, in fact, it's Ms. Topjohn and Ms. Bernone, as they were joint tenants. So the statute in the case law says there has to be a debt that was owed by Ms. Topjohn to Ms. Bernone in order to have this deed deemed a mortgage. And candidly, in this case, there is zero debt that Ms. Topjohn owes Ms. Bernone. The summary judgment evidence revealed, and Ms. Topjohn admitted, she didn't owe anything to Ms. Bernone. The summary judgment evidence revealed.
Mr. Gibson?
Yes.
Could you wait one moment? I think Judge Northcutt, here he is, he's back.
now I'm back. Sorry about that. I have ghosts in the machine.
No problem.
Go ahead,
If I
Mr.
could,
Gibson.
I'll back up for just a second. I'm not sure how long we lost Judge Northcutt. The point I was making is under 697.01, the statute says a deed can be deemed a mortgage if the deed is given to secure the payment of a debt or money. And the cases that we've cited say that that has to be a debt owed from the grantor, in this case, Ms. Topjohn, owed to the grantee, in this case would be my client, Ms. Bernone. The summary judgment evidence revealed that there was no debt owed by Ms. Topjohn to Ms. Bernone. She didn't borrow any money from her. And in fact, she was not a signer on the bank loan that was secured by the mortgage on that property. So it can't be the deed cannot be a mortgage because there's nothing to redeem. There's no debt that can simply be paid off to get the title back. The debt is not the bank loan. It can't be the bank loan because that was not a loan that Miss Bruno made to the plaintiff. It
Mr.
was a
Gibson,
bank
hold
loan.
on, Mr. Gibson, I'm sorry, hold on a moment again.
You did lose him. I apologize.
It's not often that we have these technical difficulties, but every so often one pops up.
Judge Silverman,
Yes,
it looks like he may have dropped off. If we could just give it a couple seconds for him to come back.
very good, thank you.
Okay, can you hear me?
We can hear you, Judge Northcutt,
Sorry about that.
but we can't see you. Your camera may not be functioning.
Yeah, I don't know what to start. Okay. There we go. I switched to my phone. Sorry about that. And now you can see my house.
We can see Mr. Gibson. I'm sure Judge Northcutt will give you an extra minute to recover the ground that you've covered.
Absolutely will. Sorry, Mr. Gibson.
No, not a problem at all.
Okay,
Everyone's
how
all
about it?
set?
All set.
Great, thank you. Again, just to backtrack a second, the point to be made is there was no obligation that Ms. Topjohn owed to my client. She couldn't just say, here's a certain amount of money, give me the deed back, because there was no loan made. She couldn't just pay off the mortgage because number one, she wasn't even on the loan itself. Yes, she signed the mortgage, but that loan was not made by Miss Bernone to her. The loan was made by the bank to Miss Bernone.
Mr. Gibson, I'm curious about one thing. No one has addressed the statute of frauds in relation to any obligation of Ms. Topjohn to repay, whether it's directly to your client or indirectly to the benefit of your client, to repay the bank. Is the statute of frauds relevant in any way, or is that just something that comes to my mind and has no relevancy here?
Yeah, from what I saw of the case law, when you're trying to determine whether a deed is a mortgage, you are in equity and parole evidence is admissible. We didn't raise that argument. It's not been raised in this case, but the case law seems to suggest that even some sort of an oral agreement between the two parties could be sufficient to have the deed deemed a mortgage. But in this case, we don't even have an oral agreement. There was
We have inconsistent testimony by the two principals as to whether or not that took place. And Ms. Topjohn's position has been that it was clarified or addressed between the two of them that this was basically a friendly help as opposed to an intent to convey an interest in the property. And and your client disagreed.
The summary judgment evidence revealed that my client said, I will take this loan out in my name if you make me an owner. And when I deposed her and I cited the summary judgment evidence, both in the trial court and in this court, and none of that evidence was disputed or contested in the brief, either the initial brief or the reply brief. And what we talked about was when the deed was given, Ms. Topjohn knew that by the deed, she transferred ownership to my client. She said she understood the difference between a deed and a mortgage. She said she didn't owe Ms. Topjohn anything. My client again testified that she wouldn't have made this loan except that she became an owner. And in addition, after the closing, there are multiple admissions by Ms. Topjohn that are never addressed by her in her briefs, where she admitted their owners. She signed a notice of commencement recorded under oath that they were co-owners. She signed a notice of termination under oath that they were co-owners. The insurance policy was taken out, listing both of them as owners. Did not list my client as a mortgage holder, even though the bank was listed. There was a text or an email that was issued where she said, we are co-owners. We are joint tenants with rights of survivorship. We are 50% owners. So she may say in her mind that she didn't contemplate transferring title, but the record doesn't show that she told my client that. What the record shows is the only thing she said about possibly getting title back was that there was some discussion pre-closing that if something happened to their relationship, that she thought she would get the property back. My client did deny that, but otherwise, Ms. Topjohn did not deny that my client said, I'll do this if I become an owner, and in fact admitted over and over and over and over that in fact she was an owner. The other, I think we may have lost.
There we go.
There's Judge Northcutt. The other point to be made is on the cases that look at this issue, is a deed, a mortgage or not, is there has to be an obligation to repay the debt. There has to be an obligation. In the Thomas case, there was a contract, two brothers, brother A, it's AC and LC, I don't remember which one was which, but one brother transferred title to the other brother, who then got a loan on that property and his own property in a bigger amount, paid off the debt of the first brother, but the first brother signed a contract that obligated him to buy back the property. We don't have that here. In all of the cases, the courts found, all the cases cited, even the McClendon case, the court looked at the evidence and held and found that there was some sort of an obligation to repay the advance made by the grantee. We don't have that here. Nothing like that happened. I'm checking my time. I got a little off track with the, I guess I got a few minutes. So
Yeah, you've got, I have you with on the clock, 9 minutes left, and I think maybe we should call that like 11.
that's fine. So I think the key is there is no debt that Ms. Topjohn owes to my client that Ms. Topjohn owes that my client could enforce to foreclose a mortgage. How would my client foreclose? Foreclose what? There's no debt that's owed to foreclose on. There's no debt to be paid off to redeem the property. So it may be that in her mind, she thought this was some unsupported gift of some sort or something, but the only relief they sought at the trial court was to declare the deed a mortgage. They didn't claim any sort of fraud or mutual mistake to try to undo the deed. That was never raised, never argued, not an issue. That's really what I think Mr. Dent is arguing here. And this whole consideration issue, again, the trial court, the summary judgment evidence revealed, my client said, I'll make this loan if I become an owner, which Ms. Topjohn conceded to and admitted. So on that first issue, because there's no debt that's owed by Ms. Topjohn to my client would have no way to foreclose a debt that doesn't exist. And if you don't have a debt owed, then, then it can't be a mortgage. Now, absent questions, I'll move on to the accounting issues. I know they weren't addressed in oral argument, but I do want to touch on them briefly. So the first summary judgment order in December of 19 found that it was jointly owned property, wasn't a mortgage, ordered partition. We then, I think in September, October of last year, we had a trial. And on the day of trial, the court entered a partial summary judgment on an accounting issue. The accounting issue dealt with 3 time frames. The time frame was from 92, when Ms. Topjohn first brought the property, until 2003, when she gave the deed to herself and to my client. Second time frame was from 02 until 2017, when the party split up. Third time frame was 2017 and later. On the day of trial, the court entered a partial summary judgment in that middle time frame from 02 to 17. And they've made arguments here that they should get certain expenses reimbursed 50% each. But at the trial court level, Mr. Dent stated on the record, which is talked about in my brief, that they were not seeking any contribution for that time frame. So there is no claim made for that, despite what was raised in the appeal. The second point is, and what they argued on appeal was there are certain credit card expenses they use to pay their personal expenses that they want to have credit for from the partition sale. We talked about in the answer brief, on the partition, the court's got to look at expenses related to the property, mortgage payments, taxes, insurance, repairs. There's no evidence that the credit cards were used for any of those property-related expenses. The trial or the summary judgment issue showed that those were personal credit cards for personal expenses. So even though they said we're not seeking at trial court any of these expenses, they are arguing the credit card. They've waived it. They gave up on it at the trial court level. In any event, it's not something that can be addressed in an accounting issue. The second time frame, or the trial, then focused on the 92 to 03 time frame. During that time frame, my client didn't even own the property. She didn't live in the property. She did about the last year of that time frame before the title got transferred, but she was not an owner of the property. The trial court got it right. The trial court, bear with me, cited I think the Fernandez case, where in that case, they looked at where one of the co-owners tried to get money they paid pre-closing. The trial court, in that case held, the trial court wrote, why would somebody be responsible when they're not even an owner to pay the expenses of a property that they don't even own? And I think the Fernandez case holds that, and there's the O'Donnell case that was cited that hold that same holding. And also, if you look at Biondo versus Powers, which kind of lays out the test, you figure out what the ownership is, 50-50, whatever, and then you do the accounting. It focuses on from closing of the joint ownership and later. It does not say you look at monies that you paid when you were the co-owner of when you were the sole owner of the property. So I think the trial court got it right for that time frame. The last time frame at the trial court level dealt with 2017 and thereafter. The trial court, the evidence at trial court revealed that when they split up, the parties agreed Ms. Topjohn would stay in possession and pay the mortgage and be responsible to pay the mortgage, and my client would move out. Based upon that, that's what happened. To my knowledge, she's still continuing to pay the mortgage. But in this case, she is now seeking a half contribution for those mortgage expenses. Now, the trial court held you can't do that, cited, I think, the Bailey case. And candidly, I think the result is accurate. I'm not sure the reference to Bailey is appropriate. I think this issue is resolved by the Brusciani case that we cited. In that case, it was a divorce case, husband and wife. Husband had agreed, the parties agreed the husband would remain in possession of the property. The divorce judgment did not say either party had possession. There were no kids, there was no alimony or supported issue. And the trial court said, okay, in this scenario, with the agreement, yeah, you can claim contribution, husband, but the wife gets half the rental value as an offset. That's exactly what happened here in the trial court level. They presented evidence of what those mortgage payments were, but conversely, we presented evidence, which is in the records, to what the fair rental value was of the property. And that exceeded the amount of the mortgage payments. So they would not be entitled to an offset for those mortgage payments because the rental value offset it. And that's consistent with the Barrow case that we talked about as well, where the Supreme Court in another divorce case said that if a party is in possession of the property, but there's no ouster, that the party in possession, absent ouster, has no liability to pay half the rental value or give a credit for half the rental value because there's no ouster. But if the party in possession seeks contribution for half of those expenses, the party out of possession, my client, would be entitled to offset those mortgage expenses with half the rental value. That's what Barrow held. I see we may have. Oh,
You're muted, Judge Northcutt.
Doing this by phone, obviously, and someone just tried to call me, so that kind of knocked it off.
okay.
Interesting
So
times
the
we're in.
point of the matter is, okay, maybe the wrong analysis by the trial court, but the right result. They don't get a credit for the 2017 later mortgage payments because the rental value offset it. Now, real quick, I'm not sure of the time again because of the technical issues. Just another point, if I could.
You've got about 3 minutes.
Perfect, thank you. There was argument made in the initial brief about, I think it was the Goolsby case, and the second DCA's opinion in Kelly, about there is language in Goolsby, and it's probably a little loosey-goosey, to be candid, but the language talks about the fact that if there is a judgment in a divorce case, that and a possession is given to one of the two former spouses, that the spouse who got possession could seek contribution even if that judgment is silent, and the spouse out of possession cannot seek half rental value. Now, the issue, though, is in that case, it was a divorce case where the court is looking at alimony, child support, property resolution, not just the real estate itself, but all the other issues that happen when a married couple, with or without kids, get a divorce.
Well, the question is whether the possession is an aspect of support or an aspect.
Exactly. Right.
Just right.
So my point is, and the court addressed that in the Wolf case, which we cited. My point is, this is not a divorce case. So counsel, the other side will argue, well, wait a minute, this case, Goolsby said, if there's a divorce, like a judgment in a divorce case, or an quote unquote, an agreement. So they've taken this language about an agreement to argue, well, here the parties had an agreement. So therefore, Ms. Bernone can't seek half the rental value. But the context of Goolsby and this court's second DCA opinion in Kelly was clearly a divorce case. And when the Supreme Court affirmed Kelly, the Supreme Court only affirmed the language that talked about a divorce judgment. And this, and then later, when this court issued the Wolf opinion, which we talked about, this court recognized that this rule, you can't seek a rental offset, it arises in the divorce case because, as Judge Northcutt, you astutely picked up, you've got alimony, you've got child support, all these other factors. So there's an assumption almost that if the trial court in the divorce case wanted the spouse out of possession to be able to offset the rental value, it would have been in the divorce judgment. But clearly we don't have that here. And in fact, in the DeShoney case we cited and the Barrow case, they were both divorce cases. And that rule of law was not applied for that very reason. So at that, I'll finish. Excuse me. I don't think I have any more comments. If you have questions, happy to address them.
Think you good, Mr. Gibson?
I appreciate your time. Thank you.
Okay, Mr. Dan?
Yes. In this transaction and in the record and talking about what the agreement was, in the record at page 1157, which is a deposition, which is in this case of the plaintiff, Michelle, I asked, did you ever have any discussion with Carrie regarding the ultimate ownership of the property subsequent to you, the deed that was conveyed to both of you? Yes. And what was that discussion? As I was leaving, getting ready to leave to move because she asked me to, we talked about refinancing the mortgage in her name alone. The envision that the property was hers, that to undo the transaction that had occurred, and that is guaranteeing the mortgage, was that she was then going to give up her interest and it would be refinanced in her name alone. That was the intent. That was the agreement. This was not a completed transaction that she made a gift, conveyed for consideration, or any other means, the deed that we're litigating about. It was in fact a secured transaction. And in much of the case, like in the Thomas case, it was a matter of somebody else coming in to support the loan transaction, just as this, that it was converted. A deed was in fact construed as in this case, it should be that the deed was not a deed. It was purely occasion to aid in the financing of this property so she wouldn't lose the property, facing the maturity of the loan, unable to pay it, get a loan by herself to pay it off. On that, I think in the brief, we've discussed the amounts and the various timeframes, I think are what follow what the law is in the cases on how you allocate funds. If in fact the petition goes through, we feel there should be no petition in this case, that the deed was not a deed, that it was a secured transaction to ward off the foreclosure of a maturing loan with the inability of my client to obtain financing. That's what it was. I don't think that's even disputed, and everybody is aware of those circumstances. There was nothing like, oh, we're moving in together, I want to give you half of my house, or I want to do this. No, she found out that she was facing a dire financial need. Okay, and that's what's occasioned in the Thomas versus Thomas. That the transaction was necessitated by the financial difficulties in which AC found himself. This transaction was necessitated by the financial difficulties that my client was faced with. There was an offer to come in and to help and to sign on. Somebody said, oh, to do that, to guarantee or be a co-signer on the loan, you have to be entitled. So they did a deed to occasion that. There's no testimony that conflicts with that. There's no testimony that of consideration that there was a prior discussion to when they got together and she moved in. Oh, you've moved in, and gee, let me give you half my house, or you can do it. No, it was occasioned by the facing of a financial situation that she could not enter on her own, have the ability to get out of.
Mr. Dent, just to be fully acknowledging the record, though, your client did understand that Ms. Brunone would be a co-owner of the property and that she was conveying ownership. She acknowledged that, correct?
Well,
I think the answer is yes.
That she acknowledged, and as far as the testimony, but again, I would note that all of this has ramifications of what, quote, neither one of the parties consulted nor was an attorney involved in the transaction. Her understanding what that meant, I don't think was there. I don't think that fully the transaction was that I'm making a gift. Everybody said, hey, Michelle.
Doesn't the law presumes you know the impact of what you're signing, whether you have counsel or not? Does it not?
Well, but the testimony.
I mean,
here,
otherwise, everyone would be getting out of every contract that they sign where they didn't have they didn't have a lawyer.
I understand that, but the factual circumstances taken as a whole, that she was faced with a situation that she couldn't get out of by herself, i.e. the loss of this home. So she had a financial situation as occasioned in the Thomas case. So there was an offer by a, quote, intimate friend that I'll help you out. Let me sign on the mortgage. Okay, that's agreed. Okay, the lender said, well, to do that, we have to have a deed to put the title in both names. There was no consideration, nothing other than the intimate relationship between the two parties. And now she's trying to, as occasion as we see a lot of time in matrimonial cases, they end up splitting up.
True. Mr. Dent, you are at the end of your rebuttal time.
I thank you very much. You all appreciate the time. Thank you.
Okay, thank you both. And in order to leave our virtual courtroom, you need to click the thing called the leave button.
I got that. I have
you'll
my
be gone.
assistant here too.
Again, thank you very much. Have a good day.
Hey,
All
thank you, Mr. Gibson.